Good morning, ladies and gentlemen. The panel is ready to begin today's proceedings, excuse me, and we'll start the hearing immediately this announcement is completed. Sorry, I do beg your pardon, frog in my throat this morning. May I remind everyone to keep their microphones and cameras muted except when speaking, as the technology will automatically place anyone making a noise onto the main screen. So inadvertent coughs or rustles may disturb the rhythm of the hearing. Please also remember that the inquiry is recording the proceedings and others attending are prohibited from doing so. My name is Christine Smith and I am the hearing manager today and every Tuesday and Thursday. My colleague Lee Hughes will be here on Mondays, Wednesdays and Fridays. You have my number to contact me should there be any issues you wish to raise with the inquiry team, or if there are any issues relating to the technology. We shall aim to deal with these issues as quickly as possible. The hearing will begin very shortly. Chair, I believe everyone is with us and ready to begin.
Thank you, Ms. Smith. Good morning, everyone, and welcome to day 13 of this public hearing. Ms. Scolding.
Good morning, Chair and panel. We now turn back to the evidence of Mr. Gillis. Good morning, Mr. Gillis. I just remind you that you are on oath. Now, we were interrupted midway through your evidence yesterday to interpose Mr. Corbett, who'd had some technical difficulties. I would like to return briefly to the subject of training, if I may. The first question I wanted to ask you is, do you keep records of the safeguarding training that elders, either at a congregational or at a branch level, have undertaken in respect of child protection?
We keep records of the training courses that individuals have been through. So those could include child safeguarding aspects.
Right.
I'll give you an example. Last year we had a Kingdom Ministry School, as we refer to it, for elders. And a section on that programme discussed a review of our child safeguarding policy. Right.
Okay, but again, as you identified yesterday, that's very much from a scriptural and religious aspect rather than from what some of us might call a practical aspect.
It also includes a review of our policy, which would include our legal responsibilities.
Right. So can I ask you, the NSPCC looked at your policies quite a long time ago now, back in 2009. We have a copy of the report they made behind tab B53, if you wish to turn it up. Chair and panel, B53 is file 2. And Danny, would you mind getting up NSP 000154004? Thank you very much. It's towards the bottom of the page. So this is the NSPC. I understand the Charity Commission asked the NSPCC to look at the policies, and they then wrote to the Charity Commission, but I'm assuming the Charity Commission then shared this evidence with you. Is that right, Mr. Gillis?
No, it was only when I received this bundle did I see that letter for the first time.
Right, okay. But you can see the recommendation there was that the Watchtower Bible and Tract Society of Britain should seek child protection professional assistance in developing their organisational safeguarding systems, either via a local safeguarding children's board or via an independent child protection consultancy, for example, the NSPCC or others. Can I double check? As you say, you've only seen this document relatively recently. Can I double check, have you by any chance used either of those organisations, either a local safeguarding children's board or an organisation such as the NSPCC, to help you devise the child protection systems you have?
The answer is no.
Fine.
And the reason for that basically is I keep repeating that we don't have arrangements or activities that separate children, and that is the fundamental reason.
Okay, and can I just double check? I know you've set this out in your written witness statement, but just to double check, because I wasn't sure whether I'd asked you this question yesterday, because of the approach you take in terms of the fact that parents aren't separated from your children, as I understand, your elders or ministerial servants, either within the congregation or the branch office or circuit overseers, wouldn't have DBS checks other than what we would call basic DBS checks. None of them would meet the definition of regulated activity as you see it. Is that right?
That is correct.
Thank you very much. Can I ask, how much do you spend on safeguarding in any particular year, if you're able to identify that? How much?
How much safeguarding? No, I couldn't answer that question.
Okay. And do you have any idea how much your training budget is, therefore?
Well, the in-house training that we have is, like everything else we do, is all voluntary. So right. Our schools are voluntary, our elders do their work voluntarily. So there isn't a massive budget associated with training them.
Okay, it would largely be, I'm assuming, expenses, the expenses that you might pay to fly people to the US and their accommodation and living expenses during that time. Am I right in thinking that
exactly.
That would be the cost? It might be useful, if it would be possible, if you do have such a thing as a training budget, maybe if we could ask following this hearing, if you wouldn't mind telling us details of how much you've spent on any child protection aspects of your training budget over the past 3 years. We would be most grateful for that information. Thank you.
Okay.
Now, can I turn next to issues around access to children? Now, I understand entirely that your perspective is we don't separate children from their parents, but can I ask you a couple of other questions about what I would call the way of life of being a Jehovah's Witness? Do you agree with the conclusion that Mr. Justice Globe reached in A and Watchtower, that being part of the Jehovah's Witnesses is a way of life and affects every aspect of one's life?
Yes.
And I think we also heard PRA 5s as an individual who was brought up in the Jehovah's Witnesses, and Miss Davies, all of the individuals who were brought up as Jehovah's Witnesses, saying it was part and parcel of every aspect of their day-to-day life, both their religious life, their social life, their friendship with others, their family relationships, were all bound up with the Jehovah's Witnesses. Isn't that right?
Well, it's a case that the Bible principles influence the decisions and activities that we make in life. But we have many Jehovah's Witnesses who are, say, married to people who are not Jehovah's Witnesses. So they obviously have a normal social life in association with their husband or wife and children. Sometimes they might be the only member of a family. But having said that, the answer to your question is that the principles and moral standards that we have do influence our everyday life.
And we've heard evidence from a number of individuals who gave oral evidence yesterday, and other individuals whose written witness statements you will have seen, which identifies the great deal of trust and confidence that is reposed in elders and ministerial servants, both at congregational, regional and national level. Would you agree that respect and submission is required in a courteous and respectful way towards elders and ministerial servants by children and others who are members of the congregation?
Well, members of the congregation do respect the ministerial servants, do respect the elders. Their submission to the arrangement is influenced, of course, by the Bible. We talk about the headship principle, but the headship principle is still a relative application.
And obviously, the elders as well, the literature that we've seen places a great deal of emphasis upon the congregation as like a family and having close spiritual relationships with each other. So therefore, you are encouraging deep bonds of loyalty, friendship and love, are you not?
Well, it's natural that people who have common interests and common goals and common agreement about teachings will create friendships. That's absolutely true. My friends are Jehovah's Witnesses. I have a whole abundance of friends who are Jehovah's Witnesses all over the world. So yes, we develop strong ties amongst ourselves.
And those strong ties are also reinforced in respect of elders and ministerial servants by their appointed place as shepherds of the flock, as your guidance says. So they have a role to look after and care for their congregation. Is that not right?
That is correct. But may I just add, we've been talking about our Shepherding the Flock of God publication, which is a handbook for elders. And it's interesting to highlight that it says the flock of God. So what motivates elders to actually care for individuals in the congregation is that we believe they belong to God. We believe that Christ Jesus died for every single member of the congregation, and they are precious to him. So the responsibility that we feel in caring for individuals who associate with our congregations is that we're entrusted with a care because they belong to God, not because they belong to the elders or just because they identify with a religion.
But I suppose what I'm trying to say is you exercise a duty, something which is akin to a position of trust or a duty of care to each other within the relationship, and elders have a special position of trust and duty of care towards those who are members of their congregation. That would be a relatively accurate summary.
It would be accurate to say that they take the lead in doing so, but it would also be accurate to say that every single member of the congregation looks after the interests of everybody else. We care about each other. We develop that strong scriptural bond of love. That's true, because we're trying to practice what Christians are instructed to practice, to love their neighbour as themselves.
You recognise, however, that the vast majority of child sexual abuse takes place within situations where adults are known to the children. And those who perpetrate child sexual abuse will often groom not just the child themselves, but the people around them. Do you accept that as two principles?
Oh, yes.
Yeah. And that in those circumstances, the sort of organisation you have, which encourages close familial type relationships, significant bonds of trust and confidence, may be attractive to, or a situation where grooming and child sexual abuse could take place.
Well, if you look at our child protection policy, that policy actually puts limits on the amount of trust, say, that you would have for other individuals, be it an elder, be it a ministerial servant, being it somebody else who associates with the congregation. Maybe I could refer you to my statement on the first tab, number 3, I have it. And it's a quote from the Watchtower articles that we were referring to yesterday.
Yes.
It's page 3, I think CJW 000116.
Would you mind getting that up, please, Danny?
Sorry, that's
your second supplementary statement, and it's 0. Which paragraph number is it? Paragraph number.
Sorry, I want to refer to tab number 23. I want to refer to the Watchtower article. That's not the one in the statement.
23, right? We looked at this. Is this?
Yes, this is the one where we have the our policy that was studied by all congregations of Jehovah's Witnesses last year in July.
It's B23, Danny. It's CJW 0000600001. Which particular passage, Mr. Gillis, are you interested in?
015.
015. How to protect your children.
So this is discussing how parents educate themselves.
Yes.
And I would like to draw your attention to the last sentence in paragraph 20, it says, remember that in most cases, the abuser is someone the child already knows and trusts. So that is one of the aspects of the education we give parents. Remember, it is someone they know and trust. So in other words, you have to be aware, even in a close environment, that there is the potential for somebody to abuse a trust that's given to them.
I suppose what...
And that when it says, of course, someone they know and trust, that could be anyone.
Yes. I suppose the reality is that this is all aimed at parents. Shouldn't the entirety of that article be aimed at everyone? Which is, instead of how to protect your children, shouldn't it be how to protect our children? So that every member of the congregation is fully aware of these issues, rather than placing all the responsibility solely on parents.
So this is one reason why every congregation throughout the world discuss this material, so that they're aware of the challenges that parents have and how they can cooperate with parents in child protection.
I just wanted to explore a couple of some of the examples we've had where children have spent time, whether condoned or not, shall we say, with adults on their own. The first one I wanted to ask about is field service, which is what I think colloquially by those of us might be known as door knocking, or standing with carts outside train stations or other places where lots of people might congregate. And Miss Davies, who gave evidence yesterday, explains that older men, in her experience, may well be paired with those who are under 18. So that obviously has happened and possibly continues to happen. And I think all of the witnesses yesterday talked about their experiences on field service, where they would be paired with elder members who weren't necessarily related to them. Would you agree that in reality that does happen?
I would agree that it has happened. And what we were talking about yesterday was examples that go back into the last century, 30 years ago or so. And we're talking about trying to look at our policies through through those experiences through the magnifying glass of our policies today. So the question I believe that this inquiry is looking at is, what is the policy in 2020 and how do we address that issue? Now, one of the points that was made yesterday was that the title of the article in our magazine, article number 19, is Love and Justice in the Face of Wickedness. And there's a growing recognition, the reason for your inquiry is because there is a problem with child abuse. It's getting worse and worse and has done over the years. So we've had to also look at that situation because we shepherd the flock of God under our care. We look at our policy to see how that policy can be improved to make sure that situations like those presented to you really don't occur, or there is an understanding of how individuals in the congregation can cooperate to make sure those policies work. So,
where does it say, Mr. Gillies, expressly in any of the documents? I'd be interested to know, when you are undertaking field service, children should not be separated from their parents. Does it say that expressly at the moment, or is that something you're intending to introduce?
well, let me take you to what we have said in our evidence.
Mm-hmm.
That is on my policy statement. This is the page I was referring to earlier. CJW 000116-003.
Yes, of course. That's tab B3, Chair and panel. First bundle. Yes, paragraph 10, is it?
Paragraph 10. So just to make clear that we as congregations don't have an arrangement for formal or informal separation of parents, children from their parents. So when situations like this arise, we leave it up to the parents to determine. First of all, the parents have to determine at what age they're going to have their children accompany them when they go from house to house or in our public ministry and other forms. They also have to decide what kind of training they're going to give to their children. Now, when they do that, generally speaking, if you look at a normal family activity, the husband and wife perhaps been working all week, the children have been going to school, they'll volunteer maybe an hour or two on a Saturday morning to share in this activity, and they do so in the company of others who are members of the congregation, and they'll go from house to house. For a number of reasons, we now do that in groups for even physical safety. You never know whose homes you're calling at these days and who's going to open the door and what kind of attitudes they have or any other circumstance. So we're much more security conscious as far as that's concerned than we were years ago. So how about children? Well, let's look at paragraph 10. This is in the context of Bible studies.
Yes.
But it's the same principle. It says, we do not sponsor private Bible studies for children in the congregation. Now, you'll probably come on to that. And the reason is that it is a parental responsibility. Now, the parental responsibility is not just about studying, but actually Bible studies or training is also part of the training that they receive when they go from house to house to visit people. In fact, one of the reasons a parent does that is to help them to see how you take an interest in other people and how you understand other people's beliefs. Maybe I could just show you a verse from the Bible that underpins this. It's in Deuteronomy chapter 6 and verses 6 and 7. Now, this is an instruction to parents. It says, you must love Jehovah your God with all your heart and all your soul and all your strength. So that's parents. Then it says, these words that I am commanding you today must be on your heart, and you must inculcate them in your sons. And notice the next point. Speak of them when you sit in your house, and when you walk on the road, and when you lie down, and when you get up. So in other words, what the Bible encourages is parents to develop very close ties with their children. So in all circumstances, they are teaching their children. They're using opportunities outside the house, inside the house to do so. Now, it would be wrong of us as an organization to separate children from their parents and somehow take on the role of parents. Now, having said that, if we go back to this example that's mentioned here, what about if a parent wants assistance with helping their children? We recognize that there are some situations where maybe a single parent has 4 or 5 children and they would like assistance. So that's addressed at the very top of that page that I'm referring to, just above paragraph 10 there on the screen, the paragraph above that.
It's the paragraph above, Danny. It says a single mother, for example.
Yes, so a single mother, for example, may be helped if mature Christians show interest in her children. While showing due respect for headship and consideration for propriety, overseers and others can offer spiritual support to members of disadvantaged families. But then it makes this suggestion, perhaps you and your mate or family can spend time with a fatherless boy or girl. So we understand that to fulfill our scriptural principles, and there's a verse quoted there in that paragraph, James 1:27, which encourages Christians to look out for the interests of widows and also for orphans. So we want to ensure that we fulfill that Christian responsibility. But in this day and age, we have to have guidance to say we have to ensure that we have the right propriety when we do that. And when we give support, we're not separating children from their parents, or if we do, it's in a setting which is acceptable to the parent. Now, just bringing you down to paragraph 10, Again, just on the quote that's taken from the June 2017 issue of the Watchtower, it provides a little bit of advice there. And halfway through the paragraph, we've underlined the section. It says, if a parent decides to have someone study with the children, the one who does so should not try to take over the role of the parents. Now that's talking about a Bible study. And further down, it speaks there about if such a study is conducted, it would be wise to do so either in the children's home with the parents or another mature witness around or a suitable public area. Thus, no one would have a basis to misconstrue what is occurring. In other words, how do we try to assist people because we care about people? We don't just care about the nuclear family, we care about those who are disadvantaged. And so we are fine with a parent doing that. But you see, it has to be the parent. We don't have any responsibilities as elders or a congregation to go beyond the headship principle. It is very much the parent, either a single parent or two parents, if they wish to have somebody assist in the training of their children, then that's their prerogative to do so. Now, that would apply to our field service activity as well.
Yes. Well, the question I asked you, however, was whether or not there was any direct instruction that field service parents shouldn't be separated from children in field service, given the situations that have obviously occurred. We've heard about PRA 5. I'm going to take you to another in a moment. There is nothing directly in either of those passages which deals with field service, does it? That deals with, firstly, friendships. And can I ask a supplementary question? You've just mentioned the principle of headship. Now, I may be wrong about this because I'm not a theologian, but the principle of headship, as I understand it, is one that the father is the head of the family and the mother's role in the family is separate but equal, so to speak. So what happens in the context of families where there is a single parent? Would the mother adopt the role of headship, or would that be another parental figure, such as a grandfather, a paternal figure, i.e. a male figure?
No, it's the mother.
Thank you. Can I just ask, one of the things you said was that the issues which have arisen in respect of field service all happened quite a long time ago. Can I take you to tab B63, if I may? JVW 003646. Danny, if you wouldn't mind getting this up, please. It's page 2 we need. Now, can you just tell me, what is this document? I think you were in charge of the service department, so I think you would know. This is a document, I think, that's kept centrally by the service department or the legal department, I'm not quite sure which is a summary sheet identifying various, I think, correspondence that there would have been between a congregation and the central branch. Is that right?
That is correct.
Right. And there is reference on this document to something called an S77 form. Can you just tell us what that is?
An S77 form is just a record of the fact that somebody has either disassociated themselves from the congregation or they've been expelled, disfellowshipped. Okay.
All right. So if we can look at page 2, this is 2009. This is somebody who was disfellowshipped. It's about halfway down the page. No, it's the next one, December the 10th, please, Danny. There's an incident involving victim 3, who is the 15-year-old referred to in the S77. Numerous acts of loose conduct has led to 2 acts of oral sex between LJ, who's the person concerned, and the 15-year-old. And somebody masturbated LJ on the doorstep of a call while somebody wasn't home on ministry. And this individual was also involved with numerous acts of porneia. Now, if I can just double check, I don't think we need to go to shepherd the flock of God, but porneia is the loose understanding for what might be called sexual licentiousness.
Well, it's any kind of sexual activity outside the marriage arrangement.
Sorry, I used licentiousness in the term that you would understand it, i.e. any sex outside, any heterosexual sex or homosexual or lesbian sex at all, and any heterosexual sex outside marriage. And whose confession led to that. So this was a situation only 10 years ago, just over 10 years ago, where it was plain that there were still at least some examples of field service taking place with adults and teenagers who weren't related to each other.
Yes.
Yes, okay. And can I also ask that the congregation further down the page say on 2012, so less than 3 years later, since the disfellowshipping, LJ has attended all meetings and applied for reinstatement, but more time. They pressed charges, he's pleaded guilty. He declined to have a Newton hearing due to the possible reproach brought upon Jehovah's names. The elders asked the following: can they consider reinstatement? This is the top of the next page, please, 003. Can he be reinstated before the sentence is passed upon him? If he's sent to prison, what assistance can be given him? Etc, etc. And then further down the page, it says, during the court case, the judge was highly critical of the way the elders handled the matter. And during a meeting with the elders, it was stressed to them that they should not get involved and treat both families equally. Can I just double check in those circumstances? Would it be usual, therefore, for somebody to be reinstated into a congregation less than 3 years after he was accused of and admitted to multiple acts of sexual indecent assault involving girls under the age of consent? Would that be something that would be usual?
It's not something which is usual. We make sure that somebody stays outside the congregation for a considerable period of time when they've been involved in such wickedness. But the terms for coming back into the congregation, which are the elders would assess his attitude at the time he applies for reinstatement. But nevertheless, even somebody who has that kind of a record of wrongdoing, as we would say, is somebody that would have to conform to restrictions if they were reinstated.
Right. And if I can just identify, in fact, LJ, the individual in this case, was reinstated in July 2012, so less than 3 years after the disfellowship, well, around just over 3 years after the disfellowshipping. I think if one goes to the, it says S77 form with LJ's reinstatement. At JVW00036460003, if you want to look.
Yes.
I think that's what that means. Okay. Yeah. Right. And we obviously heard yesterday from PRA5, who was another individual who talked about field service being an opportunity for the individual concerned to be able to sexually abuse her during that particular point in time. Given all of these numerous examples that we've been given, do you not think it would be sensible just to issue an edict saying field service should not take place where minors are separated from their parents in these circumstances, in the way that you have done in respect of Bible study?
Yes, we can have a look at that.
Thank you very much. Now, you've already helpfully taken us to the passage in respect of Bible study. Now, again, as I understand it, and as you've identified, studying the Bible is a central part of your education as a Jehovah's Witness. It's a central spiritual task, and you're encouraged to do so on a very regular, on a daily basis. And there's formal study and informal study as well on a weekly basis. Do you not think in these circumstances, again, you should do more than simply say Bible studies are purely private initiative? Because it's obviously encouraged by, condoned by, is a central part of your religious faith. Don't you think that the community needs to take responsibility for what happens during those Bible study sessions, given the integral nature of it with your religious beliefs?
Well, I do come back to the headship principle here. and we cannot force parents to do anything that they don't want to do or something that they do want to do. But there are some kind of controls. You haven't got it in your bundle, but going to the Shepherd the Flock of God book, chapter 2, point number 3 and subsection 3, obviously you don't have that to be able to bring it up. Yesterday, the comment was made that the service committee in the congregation, which is made up of 3 elders, would assign someone to work with their children. But actually what it says here is that this same committee of elders determine whether it is advisable for another publisher to conduct a Bible study with a child of a Christian parent. So when we hear of arrangements being made like that, the elders may speak to the parent or the parents and say, this is not an advisable arrangement. It's almost like a safety valve, where we say to the parents, no, we don't suggest that you do this. And we may remind the parents that actually it is your responsibility to study the Bible with your child. But as it also goes on to say, the elders may approve of an arrangement for that, but it would be the kind of setting where they would be reminded of the propriety of doing so in a setting where they're not actually separated one-on-one with the child.
And again, in respect of baptism, we heard yesterday that that will also be a circumstance or a situation where an unsupervised elder may well be alone with the child, or elders will be alone with the child without necessarily their parents being present. Isn't that right?
Well, let's have a look and see what we've said there. What was said yesterday would have been true in the past. We would have done that in the home of the child anyway, and an elder would have taken a young person, a youth, through the questions that we go through to see if a person's ready for baptism. Mm-hmm. But in this one, we have thought about this, and now the arrangement for baptism arrangements with youths or minors. The Organized to Do Jehovah's Will, page 210, provides the following guidance. When the baptism candidate is a minor.
Shall we get this document up? Danny, it's CJW 000116003, paragraph 11. It's behind Chair and Panel tab B3 of your bundle. It's Mr. Gillis' second supplementary witness statement. Sorry, Mr. Gillis.
Sorry.
No, it's fine.
You to do that.
We just wait for Danny. It can sometimes take a couple of minutes for him to find the document. It's 003, please, Danny, paragraph 11, just at the bottom of the page. Thank you.
So, first of all, there's a step where a youth has made sufficient spiritual progress and informs the elders that he's made a personal dedication to God in prayer and would like to symbolize that dedication by water baptism. Now, before agreeing to that request, the elders will meet with the youth on 2 occasions to ensure he has acquired a reasonable understanding of basic Bible teachings. But then it says an elder would not meet alone with the minor. It says the handbook Organized to Do Jehovah's Will provides the following guidance. When the baptism candidate is a minor, his believing parent or parents should be present for the sessions. If the parent cannot be present, then 2 elders, or an elder and a ministerial servant, depending on the section being reviewed, should be involved in each session.
So when did this particular edict come into place? Is this relatively recent?
So this publication was revised in 2005, 2015, 2019.
Okay, thank you very much. The last issue which Ms. Davies raised within her witness evidence is also the issue of mentoring. And we've seen above in the passage that you referred to us earlier, the idea of spiritual oversight of fatherless children being an example of that. And obviously, given the central importance you place on one's spiritual life, one can see that mentoring might have a significant role within your particular organisation. And would you say that there is a degree of encouragement for members of the congregation to support those who may well be more disadvantaged, who, as you identify, may be single parents with a number of children?
Well, yes, we feel that's part of being a Christian, to look out for the interests of others. And if individuals are disadvantaged, then of course we try to care for those interests. But I would still like to stress that the direction that we give is that we should do that in a setting where there's nobody will raise any questions about the propriety of how this is done.
But the mentoring may inevitably result in personal contact on a one-to-one basis, wouldn't it?
Well, there's always involvement with young people and children. Again, the mentoring, what do they mean? What do you mean by mentoring? If it's just a short period of time where they have a Bible study, we must stress that because of the headship principle, we never encourage anybody to take over the role of a parent. It is still the parent's responsibility to work in harmony with that scripture in Deuteronomy 6 and other verses in the Bible. In the New Testament, Ephesians chapter 6 says exactly the same thing. So it's a parental responsibility. There's no mentoring arrangement in the congregation. There's nothing that's formally adopted by the congregation to say, okay, now we're going to provide this arrangement for your child.
Can I ask, however, at the moment you've identified, you suggest that none of your activities meet the test for regulated activity. Given the way that organisations, and you're not alone in terms of having a flat structure, having volunteers, there are a number of religious organisations that would be organised in a similar way to yourself. And given the positions of trust and responsibility which the elders in your congregation and ministerial servants have, do you think the law should be changed so that those individuals who are elders or ministerial servants should be subject to enhanced checks? Would you find that useful for your organisation to make sure that individuals do not undertake positions of responsibility and trust who may well have had difficulties with child sexual abuse in their previous lives? How would you feel about that?
We have no religious objection to what you're suggesting.
Thank you. Can I now deal with the process for dealing with allegations of child sexual abuse when they're made? You set this out from paragraph 52 of your first witness statement onwards. I think it might be useful for us to use that as our guide. That's behind tab A1, Chair and Panel, CJW 0000520112, page 12, Chair and Panel. Danny, if you wouldn't mind getting that up. Now, again, you identify clearly that this is what you consider to be the religious procedure. The first one of which, however, is that if an accusation of child abuse comes to the attention, as we've got at paragraph 52, you're instructed to arrange for 2 elders to telephone the Britain branch office immediately for assistance. Why is this done? To provide situation-specific support, who are well versed in the child safeguarding policy of the Jehovah's Witnesses. But as we've already identified, they're not necessarily very well versed in child safeguarding practices and procedures in the secular sense, are they? So you've already identified they don't necessarily, they have training on the Jehovah's Witnesses policies, but not on what should happen. So do you not think it would be more sensible for the elders in the Britain branch office and for the elders in the congregation to be well aware of what's available in terms of the police and local authorities, which appears nowhere within any of your policies or documentation?
Well, if I can draw your attention to that paragraph, halfway down, it says there that It's qualified solicitors in the legal department who are well versed in the relevant reporting obligations to the statutory authorities. So the solicitors in the legal department do keep themselves up to date with the necessary legislation and what can be done. Now, when they speak to the legal department and speak to the service department, and if there is a statutory requirement to report, it mentions there in Ireland, there is, and that's exactly what we do. We give direction to elders how to make a report. Remember what we do as a religious body. We know that child abuse is a crime. We do not impede anybody with knowledge of child abuse from going to the police and making a report or to a LADO officer. So that is fine. But the bulk of our activity is how to handle the sin, the wrongdoing within the congregation. So when it goes through to the service department, the elders are particularly concerned to make sure that the accused is handled correctly in the context of the congregation. And most importantly, how they provide shepherding assistance to the victim of abuse.
I suppose the question that should be put to you really is, well, why don't you, if you're saying, well, everybody should know about what goes on with the statutory authorities, why isn't that anywhere in your policy? Why don't you just say to the elders, look, you're dealing with the spiritual side of things, you're dealing with whether somebody should be a member of a congregation, but that should really have nothing to do with reporting. So why is there no clear obligation to say, go to the LADO, go to the police? Why is there no imperative to do so? And why do you make people phone the branch office? Why don't you just write in your policy to the elders, everyone must go to the LADO or everyone must go to the police?
Well, these are good questions. And if I can explain why it is that they call the central office, they're looking for case-specific advice because every situation is different. Elders in the congregation may rarely have to handle an allegation of child abuse. The elders appreciate calling into the central office because they want to get it right and do exactly what is in harmony with the law and their procedures. But we have a form of mandatory reporting because when the service desk speak to the elders, they go through a number of questions, and you have those in tab 25.
Okay, maybe let's have a look at these questions in tab 25. These are the guidelines for the branch office service desk. So this is a document that the branch office holds, but elders in congregations wouldn't hold and members of congregation wouldn't have. So let's go to CJW 00062-003, which is the reporting the matter. Is it paragraph 7? You would like to take me to paragraph 7, 8 and 9?
It's paragraph 8 particularly. We can discuss other paragraphs if you wish. But paragraph 8 is there to help those taking the calls in the service department to talk through the matter with two elders. Now, bear in mind that we only have experienced elders in our service department who care for these matters, experienced in the sense of being very familiar with our policies and having years of experience as elders in handling similar matters. So paragraph 8. Can I stop
you there? They have years of experience as elders, I have no doubt, but they don't have years of experience of evaluating the credibility of child sexual abuse, and they don't have years of experience in child protection, do they?
They have years of experience in being familiar with our child protection policies. So you see, we don't pretend to adopt the role that is there for the secular authorities. As pointed out in our Watchtower magazine, their role is primarily a spiritual role. That is what they handle. They're not dealing with the crime itself.
Well, I mean, I understand that, but why then do you go through these questions? Why then do you ask these questions at paragraph 7 and paragraph 8? I understand entirely you saying we're not it's not our role to decide whether the abuse happened or not. I understand that. It isn't a religion's role to do that. But you ask a series of questions which certainly intimate that you believe that it may be your role. Do they perceive, is the alleged victim still a minor? Is there a reason to believe that anyone's in danger of abuse? Do they put him in close proximity? Regarding the alleged victim, what's the date of birth? Is the baptism? Who made the accusation? How did the elders learn of it? What's going on? If one goes on to page 9, evaluating the facts. Once the service desk has obtained the facts, the following must be determined. Now, I understand that this is to do with scriptural, whether it's scripturally established, but the reality is if the first thing you're doing is saying to people, phone the branch office, and then the branch office are focusing entirely on the scriptural aspects and are carrying out an evaluation of the facts, aren't you in effect erroneously misleading people about the role that you play in respect of assessing child sexual abuse? And doesn't that need to be made a lot clearer?
So what we're talking here about is a situation where there's an evaluation of whether the service desk directs elders to make a report to the police. Now, we could simply take the position, there is no mandatory reporting law, there's nothing you need to do, you're not obliged to go to the police. But actually we take a responsible position, because if the elders learn of an allegation of abuse and it is determined, as our policy says, that there is a child at risk, then a report will be made to the authorities. Now, those questions that you've just read are designed to help the elders establish whether the report should be made. So that's what we do in order to provide child protection. Yeah. It's because it's assessed that a child is at risk. We're not replacing the authorities. We're not stepping and doing that. We're not taking that responsibility. We're saying we've heard of this abuse. We've heard of this allegation. So let's make sure that a report is made to the police. And that is done before the elders do anything else in the congregation with regard to carrying out an internal investigation.
Can I just ask you a question about that, if possible? Danny, would you mind getting up CJW 000062003? You say quite clearly that it's not your role to determine issues. Paragraph 8, please. However, you say, is the alleged victim still a minor? Is there a reason to believe that the alleged victim is in danger of abuse? Do the accused day-to-day activities put him in close proximity to minors? Aren't you taking on the role of judge in that situation? Surely what you say is, it's not for me to know anything about what's going on. You need to refer it to the LADO, rather than taking on this kind of quasi-advisory role, which could be which could and has in certain cases led to things not being reported to the police or other authorities when that should have been the case.
Well, this is, as I say, it's a child protection policy, and we want to ensure that something is done when we learn about abuse taking place. The nature of the questions show that there is a sensitivity to the situation of a child that could be at risk. We want to take some action. So we want to give the elders guidance, because the next step is, if the service desk establish, yes, you should make a report to the police or to somebody else, then the legal department will give them guidance as to how to go about making a report.
And can I ask, when it comes to making a report, can we go to paragraph 6, if you don't mind, in terms of this branch office service desk? That's CJW 000062003. It says, if the caller is not an elder, so the service desk should listen carefully and offer scriptural comfort. This is especially important. She should be encouraged to talk with her elders or the circuit overseer if she has not done so, or write to the service department. So again, why is it that you can't accept calls from anyone? Why is it simply, why does everything have to be directed via the elders in this respect? Why isn't there a sort of sexual abuse hotline, so to speak? Or why can't the service desk be that?
Well, if you look at that paragraph, it simply says that you listen very carefully to the caller's concerns. Individuals in our congregations are free to contact our service desk. They're free to talk with an experienced elder, and they will be listened to, and they will be provided with scriptural comfort. Why are they referred to the elders? Because the elders are appointed as shepherds in their congregation, and a victim of child abuse needs ongoing assistance. A conversation for an hour or two with somebody on the service desk doesn't necessarily provide them with all the comfort that they need, because they need ongoing reassurance depending on what's happened to them. So we refer the elders, we refer them to the elders. The elders may already know about the situation. They may have already called the branch about it. Or the elders have or can put into place an arrangement for providing comfort and support. It may not be even a responsibility that the elders take on themselves. If it's a young woman, they may ask a mature sister in the congregation to assist that distressed female and help them. So,
why do you say, in these circumstances, you both say you never discourage and they may report? Why don't you encourage reporting? I suppose this is all, I would say, quite passive in terms of, on the one hand, you're an organisation which stresses strict adherence to moral codes, which has a series of very compelling requirements, shall we say, of adherence to the faith. On the other hand, so you have no problem telling people what to do in some circumstances, but you're not saying to them, you must do this, you should do this, it should always be reported. It's all much more kind of, we tell them that they can, which seems to be strangely passive for an organisation which is so active in other parts of people's lives. Perhaps you'd like to explain why that might be the case.
Yes, happily. It's because of individual responsibility and individual choice. If we go to Galatians chapter 6 and verse 5, there's a very important principle here, which it says, for each one will carry his own load. And the footnote to that reference says, carry his own load of responsibility. Now, we don't necessarily want to, we haven't got the authority as elders to insist that individuals go to the authorities. You must remember one reason why it is that a victim of child abuse could approach the elders, could call the branch office. They could be an adult victim and they've got no desire to go to the authorities. This could be something which happened to them prior to being a witness. It could be somebody that the abuser maybe not even associated with the congregation. We would respect the wishes of an adult who says, you know, I really don't want to go through all the trauma of being interviewed by the police. I don't want to go through a court case and so forth. The reason I've come to you is I want spiritual comfort and help. And that's where the elders play a very important role in being available to individuals who want to talk about their experiences they have. Now, some people don't, but many do, and they want comfort. What kind of comfort? An individual may feel that they can't pray. They can't see even the Lord's Prayer, which says, Our Father in heavens, could be a stumbling block for them straight away because the father was the abuser in a fleshly sense. So to see God as a loving father is contrary to their experience in life. So we can talk to them about that. We can reassure them of God's love for them. We can help them to overcome feelings of being unworthy, which is often the case with individuals who now in their adult life realize what was happening to them as a child. They can feel unclean before God. They wonder if they could ever be approved by God. So that's the reasons why individuals will talk to elders in the first place. It's the comfort they want. They may not necessarily want to go to the authorities. And so we would respect that right of theirs to say, no, I will carry my own load of responsibility in this matter.
But I suppose I'm so sorry to interrupt you, Mr. Gillis, but I think I must put that there is, or there could be perceived to be an aspect of double standards in this respect, in that, for example, where in the elders statement it says if there's a break-in, theft, arson or other incidents of vandalism, that should be promptly reported to the local authorities. So there does seem to be somewhat of a disjunct between property damage and personal damage. Now, I understand entirely what you say about the fact that for adults in particular, for those who are adult, they may well make choices about whether they want to pursue things by the criminal mechanism or not. But why is none of what you've just explained set out in the service branch guidance or set out to the elders? Or, I mean, we understand that there are a number of nuanced matters, and why can't the branch office report on behalf of the elders? Why can't, if you're saying things should be reported, we think things should be reported to the branch, why can't you say a number of other religious organisations will say, well, our safeguarding people will do that for you if you want? Why don't you do that?
Well, you make a comment there, you said, if you want. So again, it does come back to personal choice and personal responsibility to be able to do that. But who's best placed to make a report? When you look at our policy and the Watchtower of May 2019.
Yes, of course. That's B23, Chair and Panel. Let's have a look. It's CJW 0000600003. I think, is it 0112 and 0113, Mr. Gillis, you would like us to look at?
Yes.
Handling instances of serious wrongdoing, is that right?
Yes.
Thank you.
So it's an answer to the question in paragraph 13. Do elders comply with secular laws about reporting an allegation of child abuse to the secular authorities? The answer is yes. In places where such laws exist, elders endeavour to comply with secular laws about reporting allegations of abuse. And it makes the comment that such laws do not conflict with God's law.
Yes.
So if, for example, this inquiry recommends a form of mandatory reporting and Parliament agrees, then naturally Jehovah's Witnesses will comply with whatever the terms are of the mandatory reporting law, as we currently do in the country of Ireland, as an example. So the next paragraph says, elders assure victims and their parents and others with knowledge of the matter that they are free to report an allegation of abuse to the secular authorities. Now again, we think about responsibility and the headship principle. But the point that's made there is that those who have knowledge of the matter, elders will phone into the central office to talk with experienced elders to gain guidance. But usually the individuals who are best placed to make a report to the authorities are those who've got knowledge of the matter, and particularly if the victim is an adult.
Thank you. I note the time. I think we've gone slightly over the hour, Mr. Gillis. I think we have some more discussions that need to continue, but if we may, Chair, have a brief break for 15 minutes for everybody's comfort, given the heat of this particular day, I would be most grateful.
Thank you. Yes, we'll return at 10 to 12. Thank you.
Thank you very much, Chair.
Welcome back, ladies and gentlemen. Chair, I believe everybody is back in the room and ready to continue.
Thank you, Ms. Smith. Ms. Schooling.
Thank you very much, Chair. Thank you very much, Mr. Gillis. Just before the break, we were looking at the watchtower. If we may, Danny, if you wouldn't mind getting it back up, there were some questions I wanted to ask you about this particular watchtower. It's CJW00600112. Thank you very much, Danny. Can I just ask you some questions about the language that's used within this document, if I may? In paragraph 10, it says, the elders are primarily concerned with maintaining the sanctity of God's name. Could I just ask, what do you mean by that? Does that mean that the individual must be subjected to the whole? So the interests of the congregation are more important than the interests of the individual?
Well, there's a verse there quoted beside that.
Yes.
Matthew chapter 6, verse 9, which is the Lord's Prayer. Our Father in the heaven, let your name be sanctified, or hallowed be your name, people may say. So we're very interested in making sure that as we apply any Bible standards, we're doing it according to God's standards of holiness. So sanctification has got to do with holiness and the high standards that God gives. So we're interested in making sure that the high standards of holiness are applied in this context to our child protection policy.
Okay. But one then goes to 11 and it says, in addition, and it's just at the bottom of that passage that Danny's helpfully highlighted, if the wrongdoer is a part of the congregation, elders are concerned with trying to restore him if that is possible. So in a way, the elders are trying to back two horses at the same time, because one and the other might not necessarily be compatible with each other. Am I not right?
Well, I think you have to understand what we mean when we talk about trying to restore an individual. Mm-hmm. What is it they're trying to restore here? If you look at the end of paragraph 11, the last sentence, it says their scriptural counsel can help him to restore his relationship with God. That's only possible if he is genuinely repentant. So again, the standards of holiness connected with God's holy name, Jehovah, that's what we're interested in. And if possible, if an individual can restore his relationship with God, which is primary, that's where we try to help the individual. And,
there's nothing here about the victim.
Not in that particular paragraph, there isn't, but there's a whole article follows this, which is devoted to how you can help the victims of abuse, Article 20.
And can I ask, when you, within the context of this entire watchtower, there's lots of emphasis upon sinning. A number of the witnesses yesterday, I think, told us how many times, I think it was 20 times that the word sin is used rather than the word crime. I think it's, in fact, as I understand it, it's sinning or sinner appears 20 times, whereas crime or criminal appears only 3 times. Do you think that might give the erroneous perception that what's most important is the sin element rather than the crime element of these particular abusive behaviours?
Well, there's other references too to secular authorities, but if I could take you back to page 9 of your reference, which is the previous article.
Of course.
And it's referring to the law of the Christ here. And the law of the Christ is basically making sure that we do everything in harmony with Jesus' teachings. So what it says in paragraph 23,
yes,
halfway down, it's comparing with the nation of Israel. Mm-hmm. And it says, under the nation of Israel, under the law, appointed men were handled not only spiritual matters, but also civil and criminal cases. But then it says it's different in the Christian congregation. Under the law of the Christ, the elder's role is to handle the spiritual aspects of the wrongdoing. They recognize that the secular authorities have the God-given responsibility to handle civil and criminal cases. And that includes the authority to impose such penalties as fines or imprisonments. So it's very clear that we helped our elders and helped our congregations to understand what is the role of elders when it comes to handling matters of child abuse. And so the next article really is talking about how the elders balance the qualities of love and justice in the face of wickedness in the congregation. So it's not as if there is a push aside and saying the sin is more important. It's the fact is that the secular authorities handle the crime, they deal with it, but then how do we handle the sin within the congregation?
Right. Can I just identify, as far as the fact that there is reporting to the secular authorities, can I just ask you about one particular piece of language, which is, Danny, would you mind getting up CJW 000600112, and it's paragraph 13, Danny. And it's, do elders comply with the secular laws? We looked at this before the break, Mr. Gillis, so I just wanted to ask you the question. It says, in places where such laws exist, elders endeavour to comply with secular laws. Why do you use the word endeavour? Do you know why that choice of word was used rather than must or will, or, you know, will or must would seem to me to be a more appropriate choice of language than endeavour, which has an element of, shall we say, discretion?
Please keep in mind that the Watchtower is written for 8.5 million Jehovah's Witnesses worldwide. It's reproduced in hundreds of languages on our website, and it's available in all those languages so that the entire worldwide brotherhood of witnesses is familiar with our policy. So you have to take into consideration, this is not just talking about the British Isles, it's not talking about Western countries, it's also talking about countries where there may be a breakdown of law and order. There may not be the possibility to report to the authorities even if there's a law. One example that comes to mind just now, and I don't really know how they're handling matters, but Jehovah's Witnesses have been banned in Russia as a legal entity, as organizations. So I cannot imagine two of our elders going to a police station and say, we represent the local congregation of Jehovah's Witnesses and we've come to report a case of child abuse. They would probably get arrested and put in prison for 6.5 years for identifying themselves in that way. So you have to consider that this magazine is written for the world. And so wherever they possibly can, they endeavor to apply the laws. It just makes that, gives you that option.
Right. Can I also ask a question? You say that there is, there should be respect given to those who choose to report. However, there are a number of cases, some of which we're going to come on to, some of which we've already discussed, and there is certainly within previous watchtowers views of not wanting to take against your Jehovah's Witness brothers, not wanting to take them to court unnecessarily. There's diktats identifying that that's the case. And as well, plainly, your beliefs mean that God ultimately judges everyone and will judge you at the moment of your death and during the course of your life. And therefore, even if maybe you don't get your comeuppance in the criminal law, God will make sure that that happens. Do you think that both those imperatives may erroneously lead people to believe that they don't have to or shouldn't report their fellow Jehovah's Witnesses to the police?
First of all, from a Bible point of view, there is no prohibition about reporting child abuse to the authorities. We can take our brother to court. That is very clear. I've made that clear in my witness statement. How individuals choose to handle the matter is very much up to them. You know, individuals may feel, what is it that gives them the greatest peace of mind? Do they want to keep playing over and over and over the abuse? Do they want to repeat it? in a court setting? Do they want to be interviewed by the police? Are they happy just for the sake of their own emotions to be at peace and allow things to be in God's hands? Some might reason that way. But I would like to point out too that while you've got that Watchtower magazine open, that we have made it absolutely plain that there is no disloyalty to the congregation by making a report. It's page 11. It's paragraph 14 at the top of the page.
Yes.
And it says, what if the report is about someone who is part of the congregation and the matter then becomes known in the community? Should the Christian who reported it feel that he has brought reproach in God's name? No. The abuser is the one who brings reproach on God's name. So that's clear that there is there's no need for a person to feel that they would be bringing reproach on the good name of Jehovah's Witnesses by reporting to the authorities. In fact, it's the abuser themselves who's damaged the reputation.
I suppose the last question I'd like to ask you about the language that's used within this particular document is about the fact that you identify abusers in effect as being the wicked ones, as being those who are sort of outside God, and that it's a worldwide plague and wicked men and imposters abound. That's CJW. Danny, would you mind getting out 0000600010? Some professing to be part of the congregation have succumbed to the perverted fleshly desires and have sexually abused children. Let us discuss why child abuse is such a grave sin. I suppose in those circumstances, is there not a risk that what happens is that you're trying to define those within the Jehovah's Witnesses? You're trying to, in effect, say it only happens to those who are outside the faith, rather than recognizing that certainly, you know, even from your own accounts and your own records, there have been a number of elders and those who've had senior positions within the church who have been responsible for child sexual abuse. Do you not accept the fact that there might be some sort of disconnect there, that there might be a view that these people are kind of outliers rather than this could happen to anyone? Or do you not agree with that?
Well, I think the important thing is, which is being highlighted there on the screen. In addition, some professing to be a part of the congregation have succumbed to perverted fleshly desires and have sexually abused children. Now, the point that was put yesterday was that they are peripheral to the organization, but I would like to balance that statement with what I referred to earlier in my testimony today. And that's if you go to page 15, paragraph 20.
Yep.
The last sentence. Remember that in most cases, last sentence, the 20, that's right. Remember that in most cases, the abuser is someone the child already knows and trusts. So there you've got a situation where you're saying, okay, this is not just wicked people who decide to become Jehovah's Witnesses in the hope that they can fulfill their perverted desires in our community. This is a warning to be able to say, you look, it does happen. And it could be anyone in the congregation that does that. Once you start isolating certain groups of individuals, you might neglect other groups and say, well, what about them? Or what about that person? And so forth. See, as I mentioned yesterday, we have hundreds of thousands of Jehovah's Witnesses coming into the faith every year. What background do they come from? They have to be on guard. Now, I'm not saying that everybody's a potential threat, but the point is that the whole purpose of this article was to put the congregation and parents on alert that there are individuals who will abuse the privilege of being in the congregation, if they're allowed to.
Can I double check now? Now, can we go now from the original phone call through to if there is a scriptural investigation. And if I can ask you to turn to Shepherd the Flock of God, can we go to it's tab B24, Danny, it's CJW 000610004, and I have on my note, one has a chapter 14 that deals with child abuse. And if one goes to investigating allegations, paragraph 18, that's 041.
Sorry, which chapter is that then?
Chapter 14, under child abuse.
Okay. And
Yeah,
so you're on page 41?
Yeah, 041 at the bottom. If you look at the bottom right-hand corner, Mr.
Yes.
You should have CJW, a whole string of numbers, and then 041. Paragraph 18, investigating allegations. Do you have it?
Yes.
Just Chair and Panel, just for you, B24. The elders, etc., after receiving assistance from the branch office, the body of elders will appoint 2 elders to investigate. These elders should carefully follow the scriptural procedures and the Bible-based direction in this chapter and in chapter 12. And it then says, during this investigation process in the Judicial Committee, a victim is not required to make her allegation in the presence of the alleged abuser. Now, can I just clarify, that was not always the case. Until I think the past 5 or 6 years, it would routinely have been the case that the victim and the accuser may have had to question, may have had to be in the same room together and have discussions with each other. Is that right?
Well, it's been the case, as long as I can remember, that no child was ever forced to or brought before a committee to face their accuser under any circumstances, even in the investigation process. That's long been our policy. It's also been our policy that nobody, as it says there, is required to make the allegation in the presence of the alleged abuser. Now, it could be that an adult abuser asks the elders to be present because they want to confront their abuser with the evidence that they have. Now, the elders can actually choose whether that individual is invited to a hearing to make the allegation.
So there may be circumstances in which the adult victim of child sexual abuse would be expected to attend an investigation, a judicial committee, so to speak, and give their evidence in the presence of the abuser and be asked questions by the abuser.
You use the word expected there, and it's not expected, no. In the investigation process, the victim has to be dealt with very, very sensitively and caringly. And so how do the elders go about their investigation? Well, they have to gather the evidence. How does the victim want to communicate that evidence? They may wish to do that in the presence of 2 elders. They may wish to have a friend with them as they say what's happened to them. They may prefer to put it in writing. So there is nothing expected of a victim as far as the investigation process is concerned. And when it comes to the judicial hearing, if there's enough evidence, if the individual has confessed to the wrongdoing anyway, there is certainly no need to talk further to a victim. And there is no expectation that the victim will be present there in front of their abuser. That would be totally insensitive to ask them to do that, because they already have the statements from the victims anyway.
Okay, well, I mean, I think there might have been some circumstances where that may have happened. Could I ask you to look at Exhibit B29? Danny, would you mind getting up CJW 000096 at page 17? B29 is the last one. This is a Charity Commission report into the Manchester New Moston Kingdom Hall. and Jehovah's Witnesses. It says here, if one goes to 17, it says at the paragraph beginning, the inquiry established that face-to-face meetings went ahead as scheduled. He was not a member. Person B, who is the alleged complainant, was distressed by his presence and complained. She had asked to make a formal complaint, which was still unresolved. The committee asked him to leave. And one then goes to the next page. The inquiry, no, sorry, not the next page, the next paragraph, please. The inquiry has evidence that meetings lasted for more than 3 hours and heard separate testimonies. The witnesses were asked inappropriate questions by both members of the appeal committee and Jonathan Rose, who was the alleged abuser. One member of the committee asked person B, did you ever egg him on, goad him on? Jonathan Rose was allowed to ask person B, what was I supposed to have done to you that night? As she had already provided an account of the natures of her abuse, she responded, you know what you did. Person B explained that she understood a member of committee to be instructing her to go into detail by telling her, answer the question. Person B did as she was instructed and gave her testimony again in front of 7 elders and Jonathan Rose. So this was in, as I understand it, 2014, 2nd of April 2014. Are you therefore suggesting that what the elders did in that case was out with the relevant guidance or inappropriate, or in fact that was the guidance as it was in place and it now has changed?
Well, what I'm saying there is that nobody is required under those circumstances to face their abuser. I've made comments on that on page 25 of my first statement. And this is from the elders themselves who handled the matter.
Right. And let us get up page 25 of your first statement so that we're clear about that. That is Danny CJW00052. And is that, that is paragraphs 90 and 91. And I think if we look at paragraph, no, it's 025, Danny. Thank you so much. Next page. Yes, it's here. And I think it says the congregation's trustees thus strongly disagree with the facts and the conclusion as set out in the report.
Yeah, so the first part of that paragraph, it says in part that the Charity Commission expressed the view that the congregation's trustees acted inappropriately because one of the 3 adult victims was allegedly required to confront her abuser during an ecclesiastical judicial committee. There was another 2 involved, and they obviously were not required or didn't want to be at that judicial hearing. So further down the paragraph, it says that the elders involved in the Ecclesiastical Judicial Committee confirmed that at no point was the victim required to confront her abuser.
Well, no, can I just say, we might be dancing on, can I say that there might be a degree of dancing on the head of a pin here? Because at no point was she required to confront her abuser, but she was, according to the Charity Commission's report, required to and asked questions about whether or not she goaded him, she led him on, whether or not, you know, in fact, she was engaged in this activity consensually, all of which, you know, could be considered to be extremely harmful and distressing, and was also asked questions by her abuser.
Well, I totally agree that that would be totally inappropriate to do that. But the point I'm making here is that we don't expect, require, force, whatever word you would like to use, to have a victim participate in a judicial hearing. If they want to be there, if they want to confront their abuser, that is one thing. And it's up to the elders to determine if that's a wise course of action or otherwise. But it's not something where an individual is required to do it. Nobody's even required to do anything as far as the ecclesiastical process is concerned. They can just refuse to participate if they wish to not to do so.
But the reality is that if you are a faithful members of the Jehovah's Witness, you are going to want to participate in the judicial committee process, and you are going to want to be engaged in any spiritual investigation, because you might see it as your duty and your responsibility in order to protect others in the congregation, would you not?
Well, that's correct. And that's why they would bring it to the attention of the elders in the first place. They want to ensure that the congregation is properly protected from an abuser. And this person was disfellowshipped from the congregation. But that doesn't mean to say that they have to do that in the traumatic presence of an abuser. As I explained previously, they could make a statement in writing. They don't even need to speak to any elders if they don't wish to do so. So we make sure that it's dealt with in a very sensitive manner, taking into consideration the feelings of the individuals.
Can I just ask, if someone's convicted of child sexual abuse, of a criminal offence, would they be automatically disfellowshipped, or would you still need to go through the scriptural process, given the requirement for there to be 2 credible witnesses for disfellowshipping to take place?
We would still go through the scriptural process to establish whether they should remain in the congregation or otherwise.
So a criminal court conviction, or for example, an employment tribunal making a finding, for example, of sexual harassment in respect of adults, or a LADO informing you that there has been a substantiated allegation, shall we say, would not be sufficient for you to activate disfellowshipping procedures. That's right, isn't it?
Well, it's perfectly feasible, we're talking hypothetically, but it's perfectly feasible that what comes out of the court hearing is sufficient for the elders to take the necessary action based on the corroborative evidence that they've heard in court.
Yes, but that would only be if there were 2 credible witnesses. And as we identified yesterday, and as I think we identified this morning, the likelihood of there being 2 people who are witnesses to an offence of sexual offending against one individual is likely to be small.
Well, do you want me to, at this point, explain the 2 witness rule?
Yes, please.
So best place to take you is to our Watchtower article.
Yes.
And I go back to the May 15 study article.
That's B23 again. Is this the same part of the article? Why are at least 2 witnesses required? Is it paragraph 15, Mr. Gillis?
Yes, and perhaps I could just preface my explanation.
Mr. Gillis, if you wouldn't mind, if we just ask Danny to get the part of the screen up so that everybody's watching along can see it. It's CJW 0000600013.
So I think the question here is, there's 3 questions. When does the 2 witness rule apply? When does it not apply? And what is the potential effect on a victim?
Yes.
I may preface my comments by simply saying that Jehovah's Witnesses are possibly unique to all the religions that we've looked at in this inquiry, in that we do have an expulsion process for child abusers. So when we expel someone from the congregation, it's a very serious matter indeed. So we have to go along with the Bible's standards of justice. And as it points out in paragraph 15, this requirement for 2 witnesses is part of the Bible's high standard of justice. And when there's no confession of wrongdoing, 2 witnesses are required to establish the accusation and authorize the elders to take judicial action. There are 3 Bible references there. One is Deuteronomy 19:15, under the Mosaic law, 2 or 3 witnesses is mentioned. Matthew 18, verse 16, which is actually the words of Jesus Christ. When he was talking about taking action, he used that very expression, that quote, out of the mouth of 2 or 3 witnesses, the matter is established. And 1 Timothy 5:19, where it's repeated in the Christian congregation. Now, the important thing to remember here is that we're talking about a situation where the elders are trying to establish whether somebody should be expelled from the congregation. And the next question is interesting, because it says, does this mean that before an allegation of abuse can be reported to the authorities, 2 witnesses are required? The answer is no. This requirement does not apply to whether elders or others report allegations of a crime. So that's a very important point to note, is that the process of establishing the truthfulness of a matter is all related to whether somebody should remain in the Christian congregation. And even then, the 2-witness rule, as you put it, only applies when somebody doesn't confess to the wrongdoing. In fact, if an individual didn't confess and it was later established that it was true, their lies would compound the wrongdoing and likely lead the elders to say, not only have you committed abuse, that you've refused to accept that and you've lied, and it's likely that they would be expelled for that reason too. Now, when you go further down there, it says, when they learn that someone in the congregation is accused, or I'm reading paragraph 16.
Yes.
When they learn that someone in the congregation is accused of child abuse, elders endeavour to comply with any secular laws about reporting the matter, and then they conduct a scriptural investigation. So it's important to remember that the process, the steps that we're talking about, is there a reason to report to the authorities? Is somebody reporting to the authorities? If the police are involved, sufficient time has to be allowed for the police to carry out their investigation into the matter. So that report can be made to the police, even if there is only one allegation, and that allegation has been denied. So I would like to stress that the 2-witness rule again applies to expulsion from the congregation, but it does not apply to whether a matter should be reported to the authorities, as pointed out in paragraph 15.
Well, I know that, but the reality is that what's often happened is matters haven't been reported to the police, but have been dealt with internally, and we'll come on to look at a couple of those in a few minutes. Can I ask you to look at, if you wouldn't mind, because I think you might find this helpful as well, the next tab along, which is B24, which is Shepherd the Flock of God, which sets out the evidence to establish wrongdoing. And this is CJW 0000061022 over to 023.
Yes.
Which says that a judicial committee would not be formed unless the wrongdoing has been established by sufficient evidence. Please note the following. There either has to be admission or wrongdoing. So if there's admission, there doesn't have to be corroborating evidence, but there must be 2 witnesses to a confession. So what does that mean? Does that mean that if somebody told me, that wouldn't be in confession unless, say, Professor J was also in the room with me?
No, it does not mean that at all. Of course, the scenario you present, it would be ridiculous to imagine that there was ever a setting when an abuser was abusing a child with somebody present there. They just don't do that, do they? So,
no, but it says there must be 2 witnesses to a confession. I'm not asking, I mean, I think you and I both agree the likelihood, well, there might be in terms of, you know, absolutely gross cases of paedophiles passing people around, but in the vast majority of cases, that isn't what happens. There must be 2 witnesses to a confession.
So the testimony of 2 witnesses is at least 2 people. If it's denied, of course, we're talking about that scenario. The one who makes the accusation.
No, but this is about confession. Admission of wrongdoing, either written or oral, may be accepted as conclusive proof, but there must be 2 witnesses to a confession. I understand entirely if the activity is denied, you say that there must be 2 or 3 eyewitnesses. That's further down the page. But why does there need to be 2 witnesses to a confession? And there isn't a scriptural a basis for that? I was just wondering, is that an error maybe?
Well, the first sentence there says admission of wrongdoing, either written or oral, may be accepted as conclusive proof without corroborating evidence. So where someone admits it, but you know, sometimes when they might be dealing with an individual, they might receive a confession, but you know, why is that person confessed? What are they confessing to? Is there something more serious that they might have done which they're not confessing to in the hope that they can get off lightly? So there might be other matters that's presented out of the mouth of two witnesses to verify that, or to make it, as it says, clear and unambiguous. It is not actually talking here about child abuse when it says this. It's talking about the scriptural basis for divorce in the congregation when there is a confession of adultery, or somebody is accusing their marriage partner of adultery. That's the context of that particular discussion there. But as far as
I know you say that that's the context of that particular discussion, but the particular chapter is headed determining whether a judicial committee should be formed. So I'm assuming that it's used generally for all activities, although obviously, as you've identified, you would, for example, say in the cases of adultery, for example, that somebody saying that their partner had behaved in an adulterous manner wouldn't be sufficient. You would also need, I'm assuming, possibly the person with whom the adultery took place to say so for the two witnesses rule to be met. Would that be correct?
Well, yes, there would have to be some other kind of evidence, again, if it was one person's word against another, to establish that.
Yeah. And here, can I just have a look at eyewitnesses? There must be 2 or 3 eyewitnesses, not just people repeating hearsay. No action can be taken if there's only one witness. Danny, I actually want to go to the top of the next page, so it's very kind of you to, if there are 2 or 3 witnesses, the elders can consider their testimony. What such evidence is acceptable to establish guilt? It is preferable to have 2 witnesses to the same occurrence of wrongdoing. The testimony of youths may be considered. It's up to the elders to determine whether their testimony has the ring of truth. The testimony of unbelievers and disfellowshipped or dissociated ones may also be considered, but it must be weighed carefully. So when you are assessing the evidence spiritually, ideally you would want 2 individuals who were Jehovah's Witnesses to be able to, for the evidence to be of the appropriate strength, so to speak. That would be what would be preferable. That's what I take from that. Am I wrong?
That is correct. And of course, bear in mind that what you're looking at here is how elders weigh up evidence to take a very serious decision about expulsion from the congregation. Now, in the case of child abuse, you could have one individual who makes a claim of child abuse against an abuser. A second individual can make the same allegation, and that would be sufficient evidence for elders to take an internal action. I believe that from the inquiry's point of view, is that it's very, very important to understand that even in the absence of the necessary evidence within the congregation, it does not impede a report going to the authorities.
Thank you. And so it's only if there is the appropriate evidence that a judicial committee can be formed.
Yes.
If you don't get to if you don't have the 2 witnesses, in a way, you don't get to that stage. So a judicial committee, as I understand it, is 3 elders, at least 3 elders, and that they will be appointed by the circuit overseer. Can I just ask, what training have they had if you may be dealing with issues, I accept it spiritually, but spiritually in terms of child sexual abuse or other matters involving sexual crimes, have they had any particular training in managing or dealing with victims of sexual crime, or in managing or training with dealing with vulnerable witnesses?
Elders, you've asked a number of questions there. Maybe I could deal with them one at a time just because you've asked the question. First of all, who appoints a judicial committee to handle matters? Generally speaking, once 2 elders have carried out their investigation, that the body of elders makes a determination who within the congregation is best placed to help the individual, the victim, and also who's best placed to form a judicial committee. In the case of child abuse, the circuit overseer is contacted because he will assign an elder from outside that congregation to act as chairman of that judicial committee. So that answers your question about how it's set up and the involvement of the circuit overseer. The second question is what qualifies them to deal with these matters? You have to bear in mind that elders are trained as spiritual counselors. They're trained how to help somebody in the congregation if they want to be helped. They make an assessment as to whether someone should be expelled from the congregation. You've mentioned just one paragraph there, but there's a number of chapters which guide elders, and whenever they are on a judicial committee, which might only be once in several years, the first thing that they do is they review all the material in this publication to make sure that they handle the matter correctly. But you see, they don't purport to provide the sort of training that you're suggesting. If individuals feel that they want to get assistance from mental health counselors or therapists and so forth, it's absolutely, they have the absolute right and freedom to do that. It's not a service that the congregation offers. We offer spiritual help.
Right. Okay. So I don't think we need to, we've dealt in a way, and we'll have a look at some examples of judicial committees when we come on. But if wrongdoing is then established and the wrongdoer is then not repentant, then they are disfellowshipped. And as my understanding is, an announcement is therefore made in the congregation saying X has been reproved. So you say in your witness statement, that announcement serves to alert all in the congregation that a baptized Christian who has committed a gross sin has been scripturally disciplined. Are any details given as to what the sin is?
So there's 2 different announcements that you may have just confused there. You talk about someone being disfellowshipped from the congregation. So there's the announcement that so-and-so is no longer one of Jehovah's Witnesses. There is a second announcement that is made that could, if someone remains in the congregation, to say that they have been reproved. So in that circumstance, there's always restrictions on an individual who has been reproved. Now, if it's a case of child abuse, then there is a series of restrictions that are placed on the individual. And it's expected that they adhere to those restrictions. Otherwise, a judicial committee could expel them from the congregation. Now, so no announcement is made from the public platform as to why an individual may either be reproved or disfellowshipped. But if it's an example of child abuse, then elders will visit parents in the congregation, and they will explain to them that the individual has been reproved, and also that they should ensure that their children have no contact with that individual. So parents and single parents, 2 parents, they're warned about that individual.
But there's not a warning that goes to the congregation generally. Simply the parents would be visited on an individual basis. That's right, isn't it?
That is correct.
And you've talked about restrictions. Who's responsible for devising the restrictions, and are they the subject of contracts? We've seen in other religious organisations, and it's the case, most religious organisations want to try and encourage people to continue to worship, even if they've been convicted of serious offending. But usually they get people to sign a sort of a contract to say you're only allowed to go to X service, you can't sit next to Y, you have to check in with the person who, you know, greets everyone as they come in. Do you have such contracts?
We don't have any signed contracts, but it's clearly explained the parameters to an individual who comes into one of our meeting places to attend meetings for worship. They know the protocols, they know what they're able to do, it's explained to them, and what they can't do. So if they refuse to meet those protocols, they're just simply told, please don't come back.
Who polices and monitors those protocols?
Well, the protocols are fairly straightforward. I mean, the elders or those who are acting as attendants in the Kingdom Hall would be aware of somebody that came into the Kingdom Hall that was, say, a disfellowship person. And those disfellowship people, of course, are very welcome to come to the Kingdom Hall. They're very welcome to join in the prayers and the singing and listen to the instruction. But they're invited to leave as soon as the closing prayer is given, so that there's no interaction with the congregation until the point where they're reinstated. So that's a restriction. Our congregations comprise of an average between 80 and 100 people. So the body of elders know who's regularly in attendance. They can spot a visitor very, very quickly. And there's enough safeguards within the congregation, because the setup in a Kingdom Hall is such that parents sit with their children, and they keep an eye on their children during the course of congregation meetings.
To what extent do those who are subject to restrictions or have been subject to reproof, even if they've repented, to what extent are they allowed to continue to attend meetings alongside their victims? So if, for example, somebody said, I'm repentant, he had committed child sexual abuse, there was then a decision that because of his repentance, he wouldn't necessarily be disfellowshipped, which is perfectly possible that that could happen, or would be quickly demonstrate his repentance, possibly by a full confession. Would there therefore be an opportunity to say, well, actually, I don't think you should attend this Kingdom Hall. I think you should go to the congregation up the road and start attending there? Or would there be an expectation that the victim and the perpetrator would continue to worship together?
It's case specific. One aspect of displaying repentance is that an individual shows sensitivity for the hurt that they've caused the victim. If they don't show that kind of sensitivity and remorse, then there's no way in which the elders would even judge them to be repentant. So we would expect that individuals would cooperate with any suggestions that were made along the lines that you suggested. But I mean, it could be that the victim is familial and in the same congregation, so part of the same family, who knows? But it would be suggested on a case-by-case basis, and I know that our service department brothers have made those suggestions to elders. Look, if the individual can attend a congregation nearby, it would be better if they did so.
And can I ask, would those people who have repented, sort of confessed but repented, so to speak, would they be engaged in preaching work, including field service?
Well, again, in our restrictions, that guidelines that's given to the service desk, it mentions about if they qualify. So if they're repentant and they're allowed to be part of the congregation, it's very unlikely that until they've established a period of time that they would be allowed to engage in our public ministry. And that could be a prohibition that applies for years if there's notoriety connected with that. But if at some point they are deemed to be qualified to share in our public ministry, they would only be doing that in the company of an elder who knows their background. They would never be allowed to work with children, even their own children in the public ministry. And they would never attend a meeting point where other children were present. So there is very clear restrictions imposed on somebody in that category.
Right. Can we have a look at removing restrictions? Again, I'm looking at the guidelines for branch office service desks here, which is tab B25. I'm having a look at paragraph 27 on page 7. That's CJW 0000620007, whether to remove branch imposed restrictions. What change has occurred, etc., etc. Is there no longer a cry of complaint about him? That's halfway down the page. 1, 2, 3, 4, 5, 6, 7, 8. Is that 8 lines down? I don't know. I'm so hot that I can't. Is there no longer a cry of complaint about him? What is that? And does that really mean that if somebody doesn't make a great big fuss, somebody will be restored quite quickly? But if they do make a great big fuss, they won't be restored quite quickly. Can you please try and explain to me what cry of complaint means in that context?
Well, in the context, it's one of a whole list of questions, and not every question particularly fits the individual.
Yeah.
But a cry of complaint could include the victim or the victim's family. They have been so distressed by what's happened. They would be completely shocked if they saw that someone was restored to what they were before in the congregation. So the elders who know the individual, perhaps know the victim, perhaps know the family, might assess there that if this happened, they would be very extremely distressed to see it. That's a factor. And that's why in some cases branch imposed restrictions could last for a very long time.
Can I ask you about the provision of spiritual assistance? You've already said that your role, if somebody is a victim, is to provide them with spiritual assistance, but not any other kind of assistance. Do you have a referral mechanism for access to counselling or therapy? Do you ever pay for pastoral support, therapy or counselling for those members of your congregation where child sexual abuse has taken place?
We don't have a formal arrangement for that. I mean, if individuals out of their care and concern wish to help somebody financially, that would be down to a Christian responsibility or a Christian concern. Our elders give of their time and provide this counselling help as they're able to in the course of their life on a voluntary basis.
But there isn't any formal counselling service, referral service to local counselling services?
No, there isn't.
Having gone through the various allegations in the abstract, I'd like to firstly take you back to the New Moston congregation. If we care to have a look at that, that's exhibit B29. This is the report of the Charity Commission. Now, we've already discussed that the facts and matters set out with it are not necessarily agreed by yourself, so let's say that. So let's just have a quick look at the background, which is CJW 0000960005, Danny. It's page 4 of 23, Mr. Gillis, chair and panel up on the top left-hand corner, B29.
Sorry, page?
005. Page 4 of 23. Mr. Gillis, it's up on screen.
Thank you. Oh, okay.
In August, the Commission was in August 2012, the Commission was notified that one of the charity's trustees had appeared in court charged with sexual offences from 2002. He was then subsequently convicted of that, sentenced to 9 months imprisonment, and in November 2013, the Commission became aware that it had alleged that during Mr. Rose's trial, they'd known about, the trustees had known about a complaint made in 1995, which hadn't been mentioned to the Commission, and then there were discussions. The inquiry dealt with various concerns, some of which are not particularly pertinent to the issues that we're looking at. I'm trying to focus on one of them. Could we go to page 12 now, please? Now, this is dealing with person B. We heard about her earlier. She was the lady who gave evidence before the trustees at the disfellowshipping meeting, or the appeal against the disfellowshipping. She was a child beneficiary of the charity. She remembers. She said she made the allegation in April 1993. She's informed the equerry that it was reported to the elders, which included the father of Jonathan Rose, and they reported them to the police, and he was acquitted at trial. She wanted her experiences to be used. She sought advice and guidance, apologised to her to the way she'd been treated after making her allegations. After the allegations had been made, person B was therefore asked to repeat her allegations. If we could go to the top of page 13, please. She was asked to meet 3 people in 2012-13 to sign a written statement, etc., etc. They described her as being a history who was economical with the truth. When person B accused Jonathan Rose of wrongdoing, he was 19 years old and she was 15. We did not view this as child abuse, but a matter between 2 teenagers. Do you accept that, thinking that a sexual relationship between a 19-year-old and a 15-year-old not being, well, it's a criminal offence, that seeing that as a matter between 2 teenagers was wrong?
Yes, most definitely wrong.
And we've already heard about the investigation. We've looked at the evidence in respect of what happened in these investigations. I suppose what the Charity Commission has a summary of their concerns at page 21. Identifying that there wasn't adequate dealing with the allegations in 2012 and 2013, and for the 5 reasons set there. Identify 1 allegation, properly take into account earlier allegations, fully enforce the restrictions the trustees placed on him, consider and deal with potential conflicts of loyalty. I think we've identified, obviously, Mr. Rose's father was an elder in the congregation, various other family members were involved. Keep an adequate written record. What have you done in the light of the publication of this decision to ensure that these matters are dealt with properly and that this situation doesn't occur again?
Well, I'd have to study these conclusions a little bit more detail, just to make any comment on it. One that stands out to me in just reading this is number 4, consider and deal with potential conflicts of loyalty within the trustee body. So when it comes to a judicial matter, even if an elder is a family member, he cannot sit on a judicial committee dealing with a relative. But in my understanding, my recollection of this whole matter with New Marston was that elders outside the congregation handled the matter, not the trustees within the New Marston congregation. So these are steps which we can and do take when there could be a potential conflict of loyalties.
Yes, but I mean, as the Charity Commission says, although the trustees did not themselves conduct the hearing, they remain responsible for ensuring that the charity's procedures do not expose its beneficiaries or others to significant risks of harm. Have you, in the light of the conclusions of the Charity Commission, changed or altered any of your practices or processes?
Well, as we've discussed one aspect of this report, and that was the occasion where the individual had an unhappy experience before a judicial committee and eyewitness. So we've made it absolutely plain in our policy. We have always said that never, as I mentioned earlier, never has a witness been required to appear before their abuser in a judicial committee. But the Charity Committee has acknowledged that we actually put that in an update to our policy. So we took that seriously and we made that clear that is our policy in this situation.
I note the time. I think we may need to continue. I have a few more questions for you, if I may. I think if we may continue after the lunch break, and if I can remind you that you're under oath and you shouldn't discuss your evidence with anybody else. Thank you very much. Chair, with your permission, may we return at 10 to 2?
Yes, Ms. Golding, we'll do that. Thank you.
Thank you very much, Chair. Thank you, Mr. Gillis.
Thank you.
Thank you.